The next case, Richard Rice versus William Bedford Greene, Sr. We'll hear this next case, then we've got to have a panel change, and we'll take a break after this oral argument is concluded. Mr. Whitehead, do you wish to reserve any time, sir?
Yes, sir. What I don't use, I'd like to reserve.
How much time?
It should be about 5 minutes.
All right, sir, you've got it. You may begin, sir.
Good morning, and may it please the court. My name is Sam Whitehead from Lexington, Kentucky, and we've got a case from the Marion Circuit Court where the facts, so far as I know, are not in dispute at all. And I'll go over them because they're a fairly short set of facts.
Counsel, just so that you're in sync with us on this thing, we've read the briefs very thoroughly and all of the record on appeal, so I think all three of us are familiar with the facts and everything. I don't want to cut you off. You're entitled to argue whatever you want to argue. I just want to make sure you understand where we're coming from.
Okay. Thank you, Your Honor. The issue here is whose title is paramount. Mr. Rice is, by virtue of his first contract with the decedent's widow, or would it be the appellee because he got a deed first? And of course, it's our position that Mrs. Schwartz had no title to convey to Mr. Greene. All she had was an expectancy interest that the statute says, and it is 733-103.1, that a will is insufficient to pass title unless it's first admitted to probate. Well, this will was never admitted to probate, either in North Carolina or Florida, so far as we know. And it was just appended to an affidavit of hers, which got it of record. It's never been scrutinized by a court.
But your client felt comfortable in obtaining title from her.
No, he didn't feel comfortable in obtaining title. His purpose was, and he was getting her to cooperate, to have the probate work done so that she would have good title. And so he was willing to pay.
He sort of put the cart before the horse in the sense.
Well, he was, but he wanted the lot, and he was willing to take the business risk of purchasing her expectancy interest and getting her to cooperate which would have been summary administration in Florida, of getting a title established in her name.
Mr. Whitehead, in your brief, you quote Title Standard 5.2 in part, and it talks, I think, consistent with the statute that you mentioned, which is that the will is ineffective to convey title. And I think we all agree with that. But the title standard goes on to say that once the will is admitted to probate, it relates back to the date of the death and takes effect as of the date of the instrument of title. So I guess my question would be, if she has an expectancy, and I think that we probably all agree that the will, assuming that this will is legitimate and all, that this will created an expectancy on her part, but certainly not marketable or even equitable title, probably. If they went out, if somebody goes out and probates the will tomorrow, doesn't Title Standard 5.2 say that that's just going to relate back in time then to the date of death, and then we just look at the recording statute to see who wins the fight?
Well, this was brought up below, and the idea being that estoppel by deed, assuming that the will were admitted to probate and it got through, the contention was made that she would be estopped by deed to deny the deed because it was a warranty deed. However, that's not according to Florida law, because both parties knew about it. Neither party was deceived. There can be no estoppel, the equitable remedy, where neither the buyer or the seller are deceived in any way.
Well, I'm not so much concerned with the estoppel by deed theory, but the question of, you filed the lawsuit to quiet the title.
Correct.
And you deranged the title. Now, if I had been the trial judge, I would have said your derangement of title was insufficient because there's a big gap right in the middle. We don't have we go from Mr. Schwartz to your client without anything in between. Be that as it may, your contention was that she had some interest in that property that she could convey to your client. That's what your lawsuit attempted to do.
She had an expectancy interest, Your Honor, that she could contract about, but she couldn't make a deed of an expectancy interest. The deed will require some kind of title, which she did not have, because the will was never admitted to probate. And it still hasn't been admitted to probate.
Well, I guess this case could be the poster child for why you should have a lawyer represent you in a real estate transaction.
Yes, sir. That's all I have. I'll reserve the rest of the time.
Thank you, sir.
I'm Bryce Ackerman. I represent Bedford Greene. May it please the Court.
Mr. Ackerman, one of the issues that concerns me about this case is the scope of the final judgment entered by the trial court. In the final judgment, he says, the title to Mr. Greene and the following described property is good title against the claims or purported claims of Richard Rice and anyone claiming under him. That's kind of part A. That part doesn't bother me. And then he goes on to say, and the title to the property is forever quieted in Richard Bedford Greene. Now, I did enough real estate work to know that your client's title stinks.
True.
And he'd be in the same position. I'm having a hard time understanding, given the sad derangement of title that both of you did, and I'm not saying that the pleading was sad, I'm saying that the chain of title here is not a model of clarity, and it clearly needs to be cleaned up, and it can be cleaned up.
Judge, the litigation is between...
But you understand, I guess if we agree with you, my concern is that this would put into the chain of title something that says that your client is got, I would say, when I see that language, title of the property is quieted in William Bedford Greene. I mean, it may be quieted in Mr. Greene as it relates to the claims of Mr. Rice, but as to the claims of everybody else in the world, you got a gap in your title that you could drive a truck through.
Acknowledge, Your Honor, the litigation is only between Mr. Greene and Mr. Rice. Although the judge probably was a bit expansive in that language, the net result of it is the same. Any other party's not joined into the litigation, it has no effect upon. So the net result of that final judgment is...
So you agree that really what this litigation purports to resolve is, as between Mr. Rice and Mr. Greene, who has a superior claim, but as to the rest of the world, it does nothing.
That's all it does. It has no effect on the quality of Mr. Greene or Mr. Rice's title. All it does is resolve exactly what the Recording Act is designed to resolve, which is antagonistic claims of title derived from the same source of title, which is exactly what
Well,
we
how
have.
can she be a source of title if she didn't have title? Why isn't this a wild deed?
You know, it's interesting.
How is it any different than if I had conveyed title to that property? I didn't have. I mean, I clearly don't have title.
The simple answer is it isn't. The answer between these two is this. The quality of their title is the quality of their title. The Recording Act will address that. If they have a bad title, then whether one's superior to the other probably makes no difference at all. But between the two of them, they do have a common source of title. If you go to both their affidavits, they both have testified that they both searched the public records, and the record doesn't reflect how, but they both obviously ended up with the determination that Virginia Schwartz is who they needed to contact and acquire a deed from, and they did that. So they unquestionably are derived from a common source of title. Whether that title's good against the world or defective, the Recording Act doesn't address that. All it addresses is that if Mr. Rice, upon having obtained his deed, had recorded it, we wouldn't be here today. He allowed Mr. Greene to go forward, having done evidently the exact search of the public records he did, and make another subsequent purchase from Virginia Schwartz. So it was designed to prevent that circumstance, to allow people to rely on the public records, and Mr. Rice's failure to record dictates that Mr. Greene prevails in these circumstances between the two of them, and that's all this judgment does.
Well, I think it probably does more than that, but you agree that what it should do, from your perspective, is adjudicate the relative interest of Mr. Rice and Mr. Greene and not make any expansive rulings on the quality of the title, which I think we all agree is severely lacking.
It's a defective title. The only parties to litigation are Rice and Greene, so I think the final judgment only impacts Rice and Greene.
Well, why doesn't it perhaps resolve the question of who has superior title? The answer being neither one of them has any title, has any right. And then leave open the question of who has a contract right against the grantor that they might have a better shot at enforcing. Why should this litigation preclude any claim that the appellant has to enforce a contract right?
Because 69501, the Recording Act, dictates who is superior to the other. It doesn't
But
address...
it deals with superiority in title. Here we acknowledge that neither one of them has any title at all.
I don't acknowledge neither have any title at all. I acknowledge they have a defective title.
But you already told Judge Orfinger that there was no equitable interest.
No, I did not tell the judge there was no equitable interest. I told him they have a defective title, and that this judgment doesn't affect
But
that.
what kind of defective title does he have?
They have failed to probate the will. When the will is probated, their title will be perfected. They will have title, so they hold essentially equitable title to the property now.
Well, I know you told Judge Orfinger that she didn't have equitable title.
He said she has a defective title, a title so wide you could drive a truck.
Your position is that she has equitable title.
Yes.
What is that based on?
Not she. Well,
I mean,
equitable
who?
title. There's a record title which shows on the public records of who is the owner of property. This case was Michael Schwartz. He's dead. So somebody, it could pass to his heirs, and you would need probate to perfect that, but there would be an equitable title. Who is the actual owner of the property once you clear up the legal niceties? And that would be Virginia Schwartz in these circumstances. And the superiority is only between these two parties. Regardless of how good or bad this title is, the Recording Act addresses that. If the public records can be relied upon, which the whole purpose of the statute is to do, then when Mr. Greene goes to the public records, Mr. Rice has a secret deed out here. He's gotten a deed. If he'd recorded it, Mr. Greene would never, ever have purchased this property, and the act would have worked as designed.
Well, they both knew that she didn't have title.
True.
So I'm having trouble understanding the argument that your client was disadvantaged by the failure to record the first bad deed. And I'm also having trouble understanding why it is that the title recording statute extinguishes any contract right he might have.
If you go to both of these men's affidavits, they filed in support and in opposition of summary judgment. They both testified. They searched the public records of Marion County. They determined Virginia Schwartz had the ownership interest, whether perfected or not, in this property. That's what they relied on. That's what the Recording Act is designed to protect, the public's right to rely on the public records. They both obtained deeds. There's no question that if he had simply recorded it in compliance, we wouldn't be here today. The Act, 695, doesn't speak to quality of title. It merely voids or makes unenforceable any conveyance that you don't record against a subsequent purchaser for value, just like Mr. Greene. They both come from the same source. They both did the same thing. They both relied on the public records. Recording Act is applicable. And there's no question. As soon as that will's probated, whoever is determined has priority here owns the property. It's a defective title, but it is a perfectible title. It can be perfected.
Thank you. Thank you. We'll give you a few minutes, sir.
Beg your pardon, sir?
I say we'll give you a few minutes to rebuttal if you want to.
Okay, yes, please. Just to put all of it into a nutshell, it seems to me that we can say very clearly the two deeds that were recorded are as dead as Elvis, because the Recording Act didn't do anything for them that they didn't already have, which was nothing. And the idea is that we should go back and see under common law who had a contract right, which was first in time, and that one would be first in right. The deeds simply don't do anything, and the Recording Act is not about creating interests. It's about distinguishing between two interests, and there were no interests in this case at all. And if you go to search the title, which Mr. Greene did, he would see a death certificate for Mr. Schwartz, and that's all he would see. He would see nothing from Mrs. Schwartz, or would he know to look. That would be the dead end of the title. And so the appellant submits that it's simply a case of the common law rule applying, which is first in time is first in right.
That's the common law rule, but that's contrary to the recording statute, so isn't it?
Yes, sir, but the recording statute doesn't resurrect a dead deed. If you can record anything as long as it's notarized in this state, but that doesn't give it any life. And so if neither of these deeds had any life, the recording of them didn't help them at all. Okay, thank you.